stream. Today I'm going to be talking some more legal news. Didn't get to finish covering the Fulton. Didn't even get to start to cover the Fulton v. Philly case. The other day when I streamed and we discussed the devilish Neil Katyal and the case in which he represented Nestle in some child slavery, and the Supreme Court decided, that was a-okay. So today, I plan to pick up kind of where I left off and look at Fulton, which is a case in which the city of Philadelphia propagated a rule within their foster care system that an anti-discrimination essentially rule within their foster care system that the in choosing foster care families, the agencies in which are receiving money from I believe the state and city, they could not discriminate in their practices of placement of children, and so one of the service providers, Catholic Charities Services, I'll tell you right now, Catholic Social Services, says no, that's against the church's tenets. Will accept LGBTQ youth, essentially arguing like they may be misguided, whatever, but we're not going to place them. We're not going to place any children with LGBTQIA plus families. I need to shut the music off because my morning brain cannot comprehend the two things, so I just need to lower the music. That their way of life is against the church's values, and so the Catholic Social Services says, we are not going to certify these families in order to place children there. So the city of Philadelphia, in some stupid decisions, stupid comments, stupid emails between one another, not so great comments to the head of the charity organization, the Catholic Social Services, basically tell the church that they should get in line, or this social services organization, the Archdiocese of Philadelphia, they should get in line with the overall Catholic Church's stance on LGBTQI plus rights, and accept these families, and the Catholic Social Services swats back saying, you're telling us how to practice our religion, and what ideologies we should or should not agree with, and you as a city employee, the head of the foster care or whatever larger department in Philadelphia that oversees the foster care system, like who are you? You can't tell me. And so the legal controversy that we'll discuss here is which framework to operate under. It's argument over two different frameworks, the Smith framework, and I forget the name of the other one, and we'll see in a little bit that name. But it essentially is an argument over what types of laws states and municipalities can pass, and if they're targeted towards religion or not. And argument is whether or not they're generally applicable laws that are not targeting specific religious practices. And there's a whole precedential line of different cases, some referencing some of the bigger cases were Santeria cases. I believe it's Florida, if not Louisiana, or somewhere down south, where laws were targeting the practice of Santeria, and on its face, it was a specific target at this religious group. So we'll see the conflict there, but ultimately the Supreme Court sides with Catholic Social Services, and we'll look at their analysis there. Then, if we have time, a case that I'm less familiar with, so we won't go in as a deep a dive. Is the California. That was, I don't know why I said it like that. California v. Texas, the ACA case, the Obamacare case. And so we'll take a look at that. Again, kind of more surface dive of what's going on there. Some of the commentary around it, as again, I'm not as familiar with this case, but we'll take a look at that. So I guess that's all I have there. Maybe jump back to a few other things surrounding Nestle, because I'm still grappling with an understanding of, and it's partially because I just haven't sat down and taken the time to kind of map it out, what portions of the case are precedential, because of that such an odd breakdown in the concurrences, the dissents, and the concurrences and dissents kind of parsing apart what they agree with, or at least the concurrences, what they agree with in Thomas's opinion for the majority. And I have one article here. Progressives earned a qualified Supreme Court win from Clarence Thomas. And this is Mark Joseph Stern, who's writing for Slate, and is typically pretty good. So I'm interested in reading that, at least that article. It's a shorter one at the end. So, that's a lot. All that said, I'm first going to start. Let's see if this seamlessly works. It doesn't. Bear with me. My fault for not setting things up properly beforehand, as always. So, wanted to start with this article here from the New York Times, discussing the voting patterns we've seen thus far of the relatively newly appointed Trump justices. So the Supreme Court's newest justices produced some unexpected results. And the term so far, including two major decisions on Thursday, the court's expanded conservative majority is fractured, and its liberals are often on the winning side. I'm actually unfamiliar with Adam Liptak, so I'm gonna have to. All right, well, I'm gonna read it right now. So the author of the article especially in the law, it's kind of important to, because everyone's such a bootlicker. Everyone is perverted by the indoctrination of law school, if you are a lawyer, and just the mythos, and I guess almost like godlike worship of the Supreme Court. So let's just read a little bit about him. So he covers the Supreme Court for sidebar. Okay. That sidebar is just a New York Times column. Graduate of Yale Law School, practiced for 14 years. Where, though, is what I'd want to know. Probably some civil, probably like legal aid or something. Joined New York Times in 2002. My sicko alert is going off. Yeah, no, it's for sure. Morning, by the way, Ben. Good to see you. But yeah, for sure is a sicko alert. Yeah. But this is you see this in the legal field, and these are the most perverted of the perverts. The U Chicago. Okay. So he writes, the arrival of Justice Amy Coney Barrett, or Amy Coney Island, in October. I honestly thought it was Amy Comey. It is Amy Coney. So this is Coney Island. Seemed to create a 6-3 conservative juggernaut that would transform the Supreme Court. Instead, judging by the 39 signed decisions in argued cases so far this term, including 2 major rulings on Thursday, the right side of the court is badly fractured, and its liberal members are having a surprisingly good run. I want to see the breakdown later, but that picture may change as the court has yet to issue the term's last 15 decisions, but some trends have already come into focus. And so there's some big cases in there left, at least in my mind. Conventional wisdom last fall was that Chief Justice John Roberts Jr.'s leadership, with its bias towards incrementalism and moderation, was over. With 5 justices to his right, including 3 appointed by Rumpft, the Chief Justice's ability to guide the court was thought to have evaporated. I'm very froggy this morning, chat. I don't know why. The story of the term so far, though, is a different one. This dude has used so far, like 3 times. Indeed, it's the court's most conservative members who are issuing hallowing dissents and aggrieved concurrences to protest a majority they say is too cautious. That majority very often includes Mr. Trump's appointees, notably Justice Brett M. Kavanaugh, who is now at the court's ideological center, replacing the Chief Justice. This is one of the more interesting but not surprising developments. Though he is allegedly a rapist, most likely I would think a rapist, but we'll go with allegedly. He was a Kennedy clerk, which doesn't mean that he's necessarily going to be ideologically the same as Kennedy, though I do believe, if I'm not mistaken, Kennedy tends to pick clerks that seem to more align with his judicial philosophy, and just, like, I guess, political leanings. As opposed to some of the other justices who historically have picked from a wide spectrum. Supposedly Scalia would from time to time pick clerks that were more liberal than his politics as a way to like push him in to represent more views. And I believe there's other justices that do that as well. So it's unsurprising to me that Kavanaugh would sit in the middle at the center here. I think there was a lot because he was connected to a Trump appointment, because of the confirmation hearing controversy. I think people in the media, or they're not so connected to the legal field, hilarious. Sorry, a friend sent me a text that was really funny. So the controversies surrounding his appointment, who was appointing him, Trump. I think the media, and even amongst like leftists trying to understand this, or like the Twitter realm, or online discourse around Kavanaugh, it tends to throw him farther to the right than what he actually is. And I think in his questions, especially this term, and particularly, I watched the ACA case, the California v. Texas. His questions seem very moderate and center leaning. So Adam is, I believe, correct here. So this term, Justice Kavanaugh, is voted with the majority in divided cases 87% of the time. I do wonder what they mean by divided cases. I guess it'd be 5-4, but according to the data compiled by these professors, in his entire tenure, which started in 2018, Kavanaugh has been in the majority 85% of the time, the highest rate of any justice since '53. Kavanaugh's record of voting with the majority in divided cases is extraordinary. Professor Epstein, and this is Lee Epstein, not Richard Epstein. The two other Trump appointees are not far behind. Gorsuch doesn't surprise me. Amy Coney Barrett does. So Justice Barrett is second, having voted with the majority 82% of the time this term, and Justice Neil Gorsuch tied for third with Justice Elena Kagan, a member of the court's liberal wing, at 80%. Justice Kagan's rate of voting with the majority jumped 12 percentage points since last term. This is the most troubling to me. Because of the and Adam does kind of make this argument later on, because of the I think the fear of this 6-3 majority, and Adam gets to it a bit here with Alito, unsurprisingly being one of the farthest right and looniest of our quite loony bunch here of 9, and I think you're going, as Adam will kind of say, you're going to see Kagan, Sotomayor, to some extent, or I guess Breyer, and to some extent Sotomayor. I talked about Sotomayor's propensity to try to get close to a unanimous decision, and in those cases where there's a possibility for a strong majority, she will vote that way. And may even be a rallier to bring some of the other liberal justices, sway them to join in on a majority opinion. And those opinions are not going to even be the most liberal of legal opinions, and those may tend to be more of your centrist idea. But so, by contrast, Samuel Alito Jr., a conservative who might have thought that his views would be embraced by his new colleagues, was in the majority in divided cases just 36% of the time. That helps explain his aggrieved tone in the concurring and dissenting opinions on Thursday's cases. The case Fulton we will talk about, and the other case on the Affordable Care Act. In the foster care case, Fulton, Chief Justice Roberts managed to gobble together an improbable 6-justice majority for an opinion that ruled so narrowly for a Catholic charity that Justice Alito, in a concurring opinion, said it might as well be written on the dissolving paper sold in magic shops. The court's 3 liberal members, Justice Kagan, Stephen G. Breyer, and Sonia Sotomayor, joined the Chief Justice's opinion, presumably with gritted teeth, and to avoid an actual decision, one written on regular paper with indeniable ink. I don't know if I said that word right. So this is what I'm getting at here, and it brings up to a point that I actually didn't bring up, but or I guess makes it more salient, stronger to avoid stronger right-wing opinion, stronger conservative opinions. They're going to join on to make it slightly more centrist. So Justice Kavanaugh and Barrett joined too, explaining that they were not inclined to make a major move when a minor one would resolve the case. And this is some of the Roberts infection going on, the incrementalism that Adam talks about earlier. Something similar happened in Thursday's second big case, this one rejecting a third major challenge to the Affordable Care Act, President Obama's health care law. The majority said the plaintiffs, 18 states led by Texas and the 2 individuals, had not suffered the sort of direct injury that gave them standing to sue. The court sidestepped questions about the constitutionality of a key provision of the law and what should happen to the rest of the court if the court held the provision unconstitutional. Adam, that was not great rating. So this is just a legal doctrine that the court follows. It's the doctrine of constitutional avoidance. So if there's a constitutional case that can be avoided, the case can be adjudicated on other grounds, can be resolved on other grounds that allow the court to avoid reading into the Constitution, interpreting the Constitution. They're going to go with that go with that inquiry instead. So Chief Justice Roberts gave the majority opinion in this to Breyer, knowing that he's going to give the modest technical opinion that he could get the most people on board with. But Alito was aghast. Today's decision is the third installment in our epic Affordable Care Act trilogy, and it follows the same pattern as installments 1 and 2. In all 3 episodes with the Affordable Care Act, Facing a serious threat, the court has pulled off an improbable rescue. Richard J. Lazarus, a law professor at Harvard, said the decision suggests that several key justices were willing to temper their views to join the chief's longstanding battle to have the court decide cases more narrowly and with a more unified voice. One thing I wanted to point out, chat, that I don't know the author realized, but interesting. And Ben, if you're still around, I think you'll appreciate interesting placement of Richard J. Lazarus after talking about an improbable rescue of the Affordable Care Act, maybe a resurrection, saving it from complete death, and Lazarus, Lazarus being resurrected by Jesus, or Lazarian pit in the Arrowverse for you DC weebs out there, the like 3 of you that exist. Look, no one in chat. I got 2 viewers. But he ended on a note of caution. What remains to be seen, he said, is whether, notwithstanding the chief's best efforts, his battle to promote a nonpartisan image for the court is ultimately a losing one. So far this term, the court's 3 Democratic appointees have voted with the majority 73% of the time in divided cases, slightly ahead of the 72% rate of the 6 Republican appointees. In the term that ended last year, the gap was 14% points in favor of Republican appointees. Interesting. I want to read that again. So far this term, the court's 3 Democratic appointees have voted with the majority 73% of the time in divided cases, slightly ahead of the 72% rate of the 6 Republican appointees. In the term that ended last year, the gap was 14 percentage points in favor of Republican appointees. Yeah, here it is. The change may be explained by strategic voting. So, this comes as like a liberal defense of the 3 remaining liberal justices. And it's a way for liberals to avoid criticizing or yell at leftists. The fucking handful of lefties in the legal field. They use this to cape for those 3 liberal justices, and it is true. I think they are strategically voting, and they think that they are like doing the best good thing when they strategically vote like this. But I don't think it is a good thing, and I honestly would rather have some scathing dissents that provide antithetical alternatives to what the conservative legal movement is putting out there. So I don't think strategic voting is doing anything to help any sort of even liberal legal movement, and is just further empowering the conservative legal movement. As Adam points out here, Alito's the one giving out these aggrieved tones and these concurring and dissenting opinions. He's the one giving these antithetical alternatives. I mean, the caveat is Alito's a fucking idiot and anything he writes is batshit, but someone who's a stronger writer that could twist the words to his advantage, he they at least have material. The conservatives at least have material to work off of. And the liberal justices voting strategically in this way now gives two sources of material for the conservative side, rather than giving us a more, left alternative. And, obviously, the dissent isn't precedent, but like dissents are important when trying to create an alternative to what the status quo is, or show that it's not working and there was a viable option, and there was another route that we could take. So moving on. All right, so we're at the strategic voting. The court's Democratic appointees have not hesitated to join unanimous decisions with conservative outcomes as labeled by the Supreme Court database at Washington University. The percentage of liberal decisions in unanimous cases so far this term is just 30, the lowest since at least 1953. What is up with 1953? And there's multiple shout-outs. The story changes in divided cases, where 64% of decisions have been labeled liberal, the highest since 1968. That is crazy. Going into this term, Professor Lee Epstein said the expectation was a bunch of divided decisions, with the three Democratic appointees getting the short end of the stick. So far, that prediction is way off the mark. So, it was a bad prediction. This outcome is, I think, much more was much more realistic, even from the beginning. This has been Roberts' thing all along. The institutional legitimacy, he is a centrist. He may be a Republican, but he's a centrist, and he doesn't want that firebrand Alito style infecting the court. That's not his legacy. And I think that aligns very much with the liberal idea of the court, the centrist idea of the court, and he's going to continue to get these what are labeled more liberal, but are very much just centrist, non-Trumpian, non-QAnon infected majority decisions. Cool. We're actually broadcasting at the right frame rate and everything today. That's good. That's good, chat. That's good. Okay. Now let me finish this article. That may change in the next few weeks. I didn't read that, whatever. As the court issues decisions in the remaining 15 cases this term, in any event, said Michael C. Dorff, a law professor at Cornell, this term's coalitions may be fragile. Of course they are. More than in most recent terms, Roberts was able to present a credible picture of a nonpartisan court, with Breyer, Kagan, Kavanaugh, and Barrett particularly seeming to go out of their way to forge centrist alliances. Yeah, exactly. Thank you, Professor Dorff. However, the justices appear to have reached a truce rather than a lasting peace. With high-profile abortion and gun law cases already on the docket for next term, ideological disagreements will likely reemerge sooner rather than later. Yes, and I think that's something that is not, something that needs to be highlighted is the content of the actual cases each term, and in the coalitions that they bring. Almost like if it's, I don't have the answer or the analysis, but there needs to be more political science analysis of the coalitions of the Supreme Court. We tend to see it as this apolitical institution, and we know that that's not the case, or at least I know it's not the case, and I hope I can impart that onto the listeners. It's going to change constantly. There's no way to like truly track it, but it'll just be interesting to have some discourse around the coalitions. Okay, moving on to Fulton. She's a long one. I am going to do my best to figure out how to cut this around. Let's see if we could read some shit first. Alright, let's read some analysis by Scotia's blog, Caping for the Court first. And then from there, we will move into the actual case and see what I could read. Okay. I'm sorry, chat. I misexplained it a bit earlier. The city made the non-discrimination law. The city found out that the Catholic, the agency was not placing children with LGBTQIA plus foster parents, so they stopped making child referrals to the agency altogether. So you're not filling your beds at the agency is losing money from the city or state. So court holds that city's refusal to make referrals to a faith-based agency violates the Constitution. So Amy Howe does decent analysis, but definitely a little bit of a caper for these liberal-leaning judges. So this is the breakdown, and this is definitely something that's helpful to look at. Okay. Breakdown. Did the city violate free exercise clause? Unanimous. Okay. Obviously, you're at least gonna get your 5 here, without a doubt. I would guess 6. Yeah, Roberts is fully on board with this. 6, without a doubt. So then, okay. So you're gonna get 6 without a doubt. You could almost possibly count on Sotomayor to rally these two, or if they are going to get on board, or Sotomayor sees an opportunity to kind of get all 3 of them on board to make this a more stable decision, she's going to do so. And then this is not surprising that these 3 would want to reevaluate Smith, because this is where the court is going to avoid this question of employment. We're going to need to go back to Smith. I'm drawing a blank so hard right now, but we'll see what Amy has to say here, and maybe it'll spark something. In a clash between religious freedom and public policies that protect LGBTQ people, the Supreme Court ruled Thursday that Philadelphia violated the First Amendment's free exercise clause when the city stopped working with a Catholic organization that refused to certify same-sex couples as potential foster parents. The ruling was a victory for Catholic Social Services, an organization associated with the Archdiocese of Philadelphia, and two foster parents who alleged that Philadelphia's refusal to make foster care referrals to CSS discriminated against the group because of its religious beliefs about traditional marriage. But the decision fell short of the broad endorsement of religious freedom that the challengers had sought. The justices unanimously agreed with CSS and the foster parents that the city's actions was unconstitutional. A 6-justice majority left intact the Supreme Court's 1990 decision in Employment Division v. Smith, which held that government actions usually do not violate the free exercise clause so long as they are neutral and applied to everyone. Okay. So that's what I was talking about with the string of cases in which there's earlier cases targeting specific religious activity. It's quite a long opinion. Summaries. Case details. Maybe it's not what I want. Okay, here's the syllabus. Smith and Black were fired by a private drug rehabilitation organization because they ingested peyote, an hallucinogenic drug, for sacramental purposes at a ceremony of their Native American church. Their applications for unemployment compensation were denied by the state of Oregon. That's so annoying when it doesn't zoom in a way that you could fucking read it. Their applications for unemployment compensation were denied by the state of Oregon under a state law disqualifying employees discharged for work-related misconduct. Holding that the denials violated respondents' First Amendment free exercise rights, the State Court of Appeals reversed. Okay, so the court in Smith, and this is a Scalia opinion, holds free exercise clause permits the state to prohibit sacramental peyote use and thus to deny unemployment benefits to the person. Oh no, so this is what was held before, right? Why am I like just being so stupid right now? Alright, we'll get back to Fulton. Chief Justice John Roberts wrote for the court in an opinion that was joined by Justices Stephen Breyer. Barrett wrote a concurring opinion that Kavanaugh joined in full and Breyer joined except for the first paragraph. Alito wrote an opinion concurring in the judgment, that is, agreeing with the result that the court reached, if not necessarily its reasoning. His opinion was joined by... I hate when there's just like summary... Amy, come on. It's just like a list of shit. It's just annoying to read. This case began in 2018 after Philadelphia City Council passed a resolution that condemned discrimination that occurs under the guise of religious freedom. This was their mistake. This was like too mask off for like the liberal, SJW agenda. They're trying to kill our religious freedoms and take our rights. I don't know why I was doing like a Batman voice. It should have been a chud voice, but so they instructed the city's Department of Human Services, which contracts with private organizations to place children in foster homes, and change its contracting practices. So then the city stops referrals to CSS. So Fulton and Tony Lynn Sims Bush went to federal court and sought a court order requiring the city to resume referrals to CSS, contended that the city's decision to cut off referrals violated several different parts of the First Amendment, free exercise clause. Federal District Court turned them down, ruling that the city's policy passed muster under Smith. U.S. Court of Appeals for the Third Circuit affirmed, finding no sign that the city had discriminated against CSS because of its religious beliefs. Supreme Court reversed. In its opinion, Roberts began by observing, and I want to get to this after. That it was plain that the city's actions had burdened CSS's exercise of its religion by requiring it to choose between curtailing its mission or approving relationships inconsistent with its beliefs, which was like just literally the crux of CSS's argument. The question before the court, Roberts continued, was whether the Constitution allows the city to impose that burden. And although CSS had asked the court to overrule Smith, Roberts noted that there is no need for the court to consider that question because the city's policy is not generally applicable. Okay, that's interesting. The provision in the city's standard foster care contract that CSS is accused of violating, which bars rejection of prospective foster care parents based on the sexual orientation, includes a system of individual exemptions that the commissioner of the city's Department of Human Services can grant in their sole discretion. If I remember correctly, this case could have even been ruled as moot, because I believe shortly after the lawsuit, Philadelphia changed the language of the law and made it more general, because there's obviously an issue with where is it with calling out religious freedom, and there's no way that these freaks are gonna take this lightly. It doesn't matter, Roberts added, that the commissioner has never actually granted an exception. If I just read on, I get there. There's the moot point, or part of the issue of the moot point. The problem Roberts made clear is the existence of a formal mechanism of granting exceptions in the first place, because such a scheme invites the government to decide which reasons for not complying with the policy are worthy of solicitude. Roberts also briefly considered but rejected the city's argument that CSS's refusal to certify same-sex couples violates a city ordinance prohibiting discrimination by public accommodations. The ordinance does not apply to CSS, Roberts reasons, because foster care agencies do not act as public accommodations in performing certifications. This argument was just like a very bullshit formal, and honestly, I'm not going to read the case because it's too fucking long. I think I have some tweets that pull out some of the important information, or the important citations. Robert's saying that the foster care agencies are not public accommodations in performing certifications is just like this formalistic legal argument of whether so the foster care agencies send a person into the homes to make a home check, a home certification, in order to say, like, okay, you meet the criteria to be a foster foster care, foster family. The city is providing the agency the funds in order to pay for its employees, in order to run its operations. They have other sources of funding, but I would say a majority of their funding, and I believe in part of, or at least in the city's brief, I'm pretty sure they had detailed like the percentage of the funding. But most of their money is coming from the city or the state. So the city is trying to argue that those funds are paying for the people. So like they're paying for the ability to do the certifications, and like it has always been a kind of practical consideration for the city, at least this part of the argument for the city to kind of, essentially contract that out. They develop the criteria, and another argument here is like, we are the ones giving the criteria. We are just, because we are providing the funds, it was like essentially in our intention to allow the agencies to do it because they have have better capacities to do so. They have the knowledge, the expertise, for like what is going to provide the best foster care family experience within their agency, like knowing their agency's limitations. And so that's the city's argument, and thus it is a public accommodation, though it is a like private agency doing the action. It's like through the funding mechanism, they're trying to argue it becomes a public accommodation. And there's an argument in there, and it's I believe one of the, or at least part of the issue with you would run into trying to make how to explain this, to get like state regulation over certain industries, and to make it a public accommodation, they'll like argue whether or not it's always been in the purview of the state, of the government, and foster care is not. Actually, scratch that, cut that. I think I just spoke out of my ass and made no sense. So, okay. This is why that fucking decision is so long. I was wondering why it was 100 and something pages. Alito wrote 77 pages, probably of nonsense. Okay, but we'll continue reading. Because the city's contracting policy is not generally applicable under Smith, the policy is subject to the most stringent constitutional test known as strict scrutiny, which means that you have to have like the compelling state interest needs to be narrowly tailored. I'm butchering the actual test, but it's like narrowly tailored and like no other options, and is promoting an important government interest that essentially can like outweigh the liberty interest or the constitutional interest of the other party, the party that's being regulated. Roberts explained he concluded that it cannot pass that test. The city, Roberts wrote, has not shown that its goals of maximizing the number of foster care families and minimizing the city's legal liability will be jeopardized by giving CSS an exemption from the non-discrimination policy. To the contrary, Roberts suggested including CSS in the program seems likely to increase, not reduce, the number of available foster parents. Roberts acknowledged the city's weighty interest in the equal treatment of prospective foster parents and children, but he concluded that it was Sorry, I got distracted. But he concluded that it was not sufficient to justify denying CSS an exemption for its religious exercise, especially when the city has a system of exemptions. CSS Roberts concluded seeks only an accommodation that will allow it to continue serving the children of Philadelphia in a manner consistent with its religious beliefs. CSS does not, Roberts emphasized, seek to impose those beliefs on anyone else. Barrett, who joined Roberts' majority opinion in full, filed a short concurring opinion that was joined by Kavanaugh and, except for the first paragraph, Breyer. CSS and its supporters, Barrett acknowledged, have made serious arguments that Smith ought to be overruled. But in this case, she continued, the same standard applies regardless whether Smith stays in place. Therefore, she concluded that there is no reason for the court to decide in this case whether Smith should be overruled. Okay, Amy's just giving us the details that I don't need. I'd rather read Mark Joseph Stern's. On the Roberts two-step. So, Roberts is fantastically gifted at this little two-step dance. The Roberts two-step, coined by, or at least I heard on the 5-4 podcast. Check them out for good Supreme Court coverage and analysis of past cases and some of the ongoing current Supreme Court controversies. But so Roberts pulls off this two-step. So the conservative legal movement is so unified and is very good at getting the cases they want on the docket, and essentially like creating controversies. So whether it's similar fact patterns or like the same issue or dealing with the same type of law, we saw this in like Whole Woman's Health, some of the abortion rights. He's kind of like, lobbing it up for the spike later on. So Mark Joseph Stern, I did a poor job describing that. Chat, I don't know why I'm getting sleepy all of a sudden. I might need to go make a Sammy and come back. But this is a short article. I'll read it. John Roberts just pulled off his greatest judicial magic trick. Mark Joseph Stern. Chief Justice John Roberts' skills as a judicial magician are well known. But this performance in Thursday's Fulton v. Philadelphia may be his finest trick yet. Somehow Roberts was able to create a 6-justice majority to hold that Philadelphia violated the Constitution when it ended its contract with the foster care agency that turns away again. Mark, you got a typo or something here. Turns away same-sex couples. He united the 3 liberals together with Justice Amy Coney Barrett and Brett Kavanaugh in support of a taxpayers-funded agency's ability to discriminate against gay people. At the same time, Roberts affirmed that preventing anti-gay discrimination is a compelling state interest. And to top it all off, he upheld a landmark precedent that a supermajority of the court apparently wants to overturn. We may never see a more masterful display of constitutional prestigitation. Whatever, that's a word I can't pronounce. And to top it all off, he upheld a landmark precedent that a supermajority of the court apparently wants to overturn. A supermajority of the court, unless this was wrong. We're not going to read through some of this. Okay, we'll go here. In 1990s, Employment v. Smith, the Supreme Court held neutral and generally applicable laws comply with the free exercise as long as they don't target religious conduct. Okay. Well, Roberts sided with CSS. His opinion for the court adopted neither of the agency's legal rationales. Instead, he determined that Philadelphia's standard foster care contract, which bars anti-LGBTQ discrimination, is not generally applicable under Smith. Roberts noted that the contract allows the Department of Human Services Commissioner to grant individual exemptions that that is, allow discrimination at their sole discretion. The commissioner has never granted an exception, but the Chief Justice wrote that doesn't matter. Because the discretion exists in theory, the non-discrimination rule cannot be generally applicable. Thus, Smith doesn't apply, and Philadelphia must satisfy strict scrutiny by providing that its rule is narrowly tailored to serve a compelling interest. It's good that Smith is around. At least for now, it's the best we got. The city flunked this test because it provided no compelling reason why its particular interest in denying an exception to CSS while making them available to others. Roberts provided a coherent account of this case, leading readers to a conclusion that is, if not airtight, at least defensible. But his reasoning does not withstand scrutiny. As Justice Neil Gorsuch explained in his concurrence, Chief Justice used a dizzying series of maneuvers to turn a big dispute of constitutional law into a small one. For instance, Roberts is uniquely good at this. For instance, the provision of the contract that Roberts found objectionable does not apply to the certification of prospective foster parents, but rather the placement of children in foster homes, a total different stage of the process. The provision that applies to certification of foster parents allows no exceptions and would seem to be generally applicable. To get around this roadblock, Roberts performed a sleight of hand, grafting the exceptions from one clause onto the entire contract. So let's read that again. The provision of the contract that Roberts found objectionable does not apply to the certification of prospective foster parents, but rather the placement of children in foster homes, a totally different stage of the process. The provision that applies to certification of foster parents allows no exceptions and would seem to be generally applicable. To get around this roadblock, Roberts performed a sleight of hand, grafting the exceptions from one clause onto the entire contract. So yeah, there was Okay, so the exception clause was essentially like allowing for discrimination in the placement of the child for the child's best interest. So the discrimination was not like bad faith discrimination. It was so that, and they use the example like Native American children, or indigenous children could be placed with someone of their own tribe so that, you know, they could live amongst their culture. If that was what that foster care agency thought was the best interest of the child. So he's taking that clause, that provision, and putting, you know, the exceptions. So the commissioner can make an exception to say, okay, we're only going to look at, you know, Native American foster homes for this child because that'll be in the child's best interest. Roberts is grafting that exception language onto the certification process, which it doesn't exist there. And what about Philadelphia's Fair Practices Ordinance, which bars anti-gay discrimination in public accommodations? Roberts simply announced that foster care agencies are not a public accommodation because they involved a customized and selective assessment. So he's essentially, in very short, saying that because the discretion is in the agency's hand and they're making this selective and customized assessment, it can't be a public accommodation because it's like this one step remove from the public, like almost a similar rationale to the Nestle argument of the corporation only making general corporate decisions. So like the state only giving taxpayer money, though, you know, just like Nestle would have a contract of what their employers or contractors have to do, you know, there's the rules that the the foster care agencies have to follow, but they are, you know, to certify, there's certification requirements that the family has to fulfill, but the agency is the one making those assessments. So Roberts is saying it's now out of the hands of the state. It's a private entity's decision making process, or like they're the ones making the decision. So it's not a public accommodation. Gorsuch pointed out this definition of public accommodation is nowhere to be found in any state statute. Instead, the majority just declares it, a new rule of Pennsylvania common law handed down by the United States Supreme Court. Ooh, a little snarky there. Despite Roberts' dubious logic, it's easy to see why all three liberal justices signed on to his opinion. First and foremost, the decision does not imperil most LGBTQ non-discrimination laws, which usually lack any exception that would trigger strict scrutiny. When they do contain exceptions, it's often for religious conduct. Roberts confirmed that ending anti-gay discrimination is a weighty state interest, quoting Masterpiece Cake Shop, for the proposition that our society has come to the recognition that gay persons and gay couples cannot be treated as social outcasts or as inferior in dignity and worth. So lower courts can continue to uphold run-of-the-mill civil rights laws that protect LGBTQ people. Moreover, as Gorsuch noted in his concurrence, Philadelphia can get around this decision by abolishing discretion at every stage of the foster care process. Moreover, as Gorsuch noted in his concurrence, Philadelphia can get around this decision by abolishing discretion at every stage of the foster care process. So saying that take it out of the hands of the agency, and they will be the ones that take it out of the hands of the agency. Let the state or whatever department is overseeing foster care agencies make those decisions, those discretionary decisions, and then you could force the Catholic Church or CSS to accept LGBTQ people. In short, it is likely clear from the start that the 6 conservative justices wanted to rule for CSS somehow. To limit the damage, the liberal justices signed on to Roberts' narrow opinion. Here we go. The strategic voting, which hands a symbolic victory to religious freedom while deciding almost nothing. Fulton is Masterpiece Cake Shop Redux. Once again, the Supreme Court has dabbled in the culture wars without handing a clear win to either side. As painful as it may be to see the liberal justices supporting a taxpayer-funded agency's ability to discriminate against same-sex couples, the strategy makes good sense. Why? Why, Mark? The alternative, overruling Smith and subjecting most burdens on religion to strict scrutiny would be much worse. Alito, joined by Clarence Thomas and Gorsuch, argued for reversing Smith in a 77-page opinion that would kick open the door to endless exemptions from non-discrimination laws for religious people, organizations, and businesses. Alito's path would imperil countless laws that happen to hinder the religious exercise, including those that allow LGBTQ equal access to employment, housing, the marketplace, and other necessities of life. I'm still confused. Should the court refrain from reevaluating Smith? I don't get what Mark is saying here. The 3 of them joining on here doesn't do anything. They could have dissented here and still joined the opinion here. It could have just been a messy case of concurrences and dissents, just like Nestle was, and it would make it even more paper thin. Unless I'm completely wrong, which I could be. I'm a fucking himbo idiot. But Barrett, in a concurrence joined by Kavanaugh and Breyer, refused to go down that road, expressing her discomfort with Smith while admitting that she does not know what should replace it, which is valid. Honestly, is valid. Within the valid only within the confines of how the Supreme Court operates currently. I think coming from Barrett, that's a decent reasoning for not wanting to overrule Smith, and I'm fine with it because I'd rather keep Smith in place for right now. Her brief opinion raises the possibility that she and Kavanaugh may have initially voted to overturn Smith, then walk back from the brink, forcing Alito to turn his majority opinion into a dissent. Okay, there we go. That's what I was confused about. Okay. Okay. So Barrett got Alito to... I mean, not Alito, Kavanaugh to walk back. The mystery is deepened by the fact that Barrett and Kavanaugh joined Tandem v. Newsom, an unsigned 5-4 decision on the court's shadow docket in April. Tandem took a much bigger bite out of Smith than Fulton did, so perhaps Barrett and Kavanaugh switched their votes between Tandem and Fulton, abandoning the revolt against Smith after helping to set it in motion. Gorsuch hinted at the possibility in his Fulton concurrence, complaining that the court began to resolve at least some of its confusion surrounding Smith's application in Tandem before pulling back in Fulton. That's another interesting thing about the shadow docket. Something I don't know, and I'd be interested in find out, and I may ask a professor of mine. If, like, precedentially, it may just be like a matter of how it's argued, but if, and there is like last in time for legislation, and like precedent is kind of last in time as well, but if, because it doesn't directly overrule it, but if you're chipping away here, but Fulton is kind of keeping it more intact, if the fact that Fulton was not a shadow docket case and was a full controversy in the Supreme Court, if it holds more weight. So 6 justices are interested in overruling Smith, again a Scalia case, but after Fulton, the Supreme Court is no closer to taking that leap. CSS will get a new contract without having to screen same-sex couples, but other LGBTQ non-discrimination laws remain in effect. Yeah. Roberts, who so recently seemed sidelined, is back in control of his court. If anyone can claim a clean victory from Fulton, it's the Chief Justice. I agree. Read that. You don't need to read that. All right, so here's some tweets from Alito's opinion from Mark Joseph Stern. And actually, before we get to those, though, chat, I have to take a bathroom break. So I will be right back. All right, we're back, chat. Okay. 1 second, and then we'll get to this. Okay. From Alito's Fulton opinion, are we certain that taking drugs for religious purposes is surely expressive conduct that falls under the free speech clause, a la flag burning? So, Alito says, not only did these distinctions lack support in prior case law, the issue in Smith itself could easily be viewed as falling into both these special categories. After all, it involved claims for unemployment benefits, and members of the Native American Church who ingested peyote as part of a religious ceremony are surely engaging in expressive conduct that falls within the scope of the free speech clause. Come on, Mark, what are you trying to say here? Are we certain that taking, after all, involved? Not only did these distinctions lack support, could easily be viewed as falling into both these special categories. What are the special categories? You're not giving me the context. All right, we're missing context, so we're gonna ignore that one. That's the Obamacare case, which I don't think we're gonna cover today. Cover that one separately. I want to just revisit this. Go back to the Nestle case. And then, excuse me. So we'll read this article, and then I think we'll call it a stream for the day. So going back to the Nestle case again, the Neil Katyal defended Nestle and Cargill in a case in which I couldn't look at Clarence Thomas's face like that. That's fucking terrifying. Absolutely, it's gonna give me fucking nightmares. So in the case that Nestle was using contractors that were employing child labor to harvest their cocoa. Technically, the Supreme Court's Thursday decision in Nestle v. Doe is a loss for human rights enforcement in the United States. The court ruled unanimously against 6 former child slaves who sued 2 major corporations for allegedly aiding and abetting their enslavement. The outcome is no surprise. What is shocking is that the defendants failed to persuade the court to immunize all corporations from lawsuits under the Alien Tort Statute. Corporations bet big on Nestle v. Doe, apparently convinced that SCOTUS would use the case to abolish corporate liability under the ATS. Yeah, so that was when we were talking about when we read through the case the other day. Thomas kept referencing, and I was kind of upset about the 3, just those 3 causes of action that were known in 1789 when they drafted the ATS, or any that Congress would create. So this may be where Mark is going, that there may be some sort of progressive win there. Instead, 5 justices concluded that domestic corporations can be sued under the statute. Nestle thus hands a narrow loss to a half-dozen plaintiffs, while opening the door to future litigation against corrupt, abusive, and lawless businesses. Plaintiffs of Nestle allege that they were trafficked from... Okay. We know this, so we're not going to read it. We know that. When Neil Katyal, who represented Nestle and Cargill, argued this case, he urged the justices to further narrow the ATS by holding that it doesn't apply to domestic corporations either. He asserted that allowing corporate liability would place U.S. firms at a competitive disadvantage and discourage foreign investment in the United States. But the court refused to adopt Katyal's position on Thursday. Instead, in a short opinion, Clarence Thomas held that plaintiffs' lawsuits focused primarily on conduct that occurred overseas, the enslavement of children in the Ivory Coast. The court has already prohibited extraterritorial application of the ATS. This precedent, Thomas wrote, required the dismissal of the plaintiff's lawsuit. Thomas's majority did not address corporate liability because it wasn't necessary to resolve the case, but in 3 separate opinions, 5 justices declared that domestic corporations can be sued under the ATS. First, in a concurrence, Justice so this is fuck up my microphone. This is what I was saying. The Nestle case was very interesting because of, you really need to sit there and write out who voted for what and what part, because the actual holding is not actual holding of any Supreme Court opinion isn't necessarily just in like what we colloquially call the majority opinion, or like the opinion that is getting released by the court. In one instance, when it's easier to discuss when it's just a strict like a plurality opinion. So you could talk about it's Planned Parenthood v. Casey, where is it? I think it's that one. Yes, Casey, where Sandra Day O'Connor provides a concurrence. So it was a 4-1-4, and her concurrence holds much of what the law that we think about when we think of Casey. Some of the limitations and the like kind of intermediate scrutiny is developed there. So this case is very interesting. There's a bunch of different concurrences and dissents, so it's a little all over the place. It's not binding precedent, but that's the thing. It doesn't necessarily have to be binding. But if these lower courts are going to be looking for how to adjudicate a similar fact pattern, if they're looking how to adjudicate a similar fact pattern, they're going to look to what is like the clearest articulation or the easiest for them to follow, and the one that has the most support, and that may be the view expressed by these 5 justices that is not necessarily binding. So they do send a clear message to lower courts that a majority of the Supreme Court is prepared to recognize this form of corporate liability. Yeah, so if there is another case and the lower court were to rule in this view, they could safely do so, knowing that if it goes to the Supreme Court under this current makeup, there's a good chance that you're going to get at least a 5-4 majority. So judges who defy this quasi-holding Nestle should be prepared for reversal at SCOTUS. Exactly. Nestle is not all good news. Thomas and Gorsuch, along with Brett Kavanaugh, sought to narrow the crimes actionable under the ATS to just 3. Alito did not endorse this view, but praised the strong arguments behind it. Notably, though, Chief Justice John Roberts and Amy Cracker Barrel declined to express any support of the other conservatives' cramped vision of the law. Supreme Court decisions affirming the power of the ATS are few and far between. Nestle does not quite qualify, but it does open the courthouse door to victims of corporate malfeasance, an outcome favored by a cross-ideological coalition of justices. It is a shame that the plaintiffs won't get a chance to argue their case in court, but by fighting all the way to Supreme Court, they gave other victims of human rights abuses a renewed and unexpected hope for justice. Yeah, let's see how that pans out. I'm not as optimistic, but it is definitely interesting. Okay, chat. I know it was a little shorter today, but it was definitely a dense one. God damn, that's terrifying. Um, but it was a dense one, a little dense for me in the morning. I might pop on later, do some gaming streams, but that's all I got for now. Again, as always, I'm Cut the Mic. Thank you for your time. Everyone have a good day. All you dads out there, dads for real, or those of you who live in the dad mindset, happy Dad's Day to you. Enjoy your day. Everyone have a wonderful afternoon. Bye-bye.